Thank you everybody for joining us for this great episode of Conversations with ICC Australia. And for those who are joining us for the first time, this is just a chance once a month for the ICC Australia community to get together and to share ideas, to profile some of our great members, and to see what's going on in the world of arbitration. Today, we're very lucky to have the Honourable Stephen Rares KC of 12 Wentworth Selborne Chambers in Sydney. He's a mediator, arbitrator, and adjunct professor of law at the University of New South Wales. And as you know, he was a judge of the Federal Court of Australia from 2006 to 2023. He has extensive experience in commercial, maritime, private and public international law. And then we also have Bastin KC. He's a barrister at Essex Court Chambers in London, also with extensive experience in very large and complex commercial litigation, as well as international arbitration under all of the major rules. Today, our speakers are going to be telling us about arbitration policy in the courts, and we're really lucky that they are joining us live from Sydney, where they've been able to meet for this conversation in person in chambers. So over to you, gentlemen. We'll also have some questions at the end, so if you have questions in the course of the conversation, don't hesitate to put them in the chat, and we'll open that up as we get closer to the end of the session.
Thanks, Emma. Thank you, Emily. Thank you, Jacqueline, ICC Australia. Thank you to everyone for joining. Our topic today is pro-arbitration policy in the courts, where from and where to. And I think this kicked off really, didn't it, Judge, with an appreciation that as the decades have gone by, the pro-arbitration feeling or policy or approach in courts in the UK, Australia, Singapore, other common law jurisdictions has really grown and improved. There's been quite a sea change, hasn't there, from, say, the pre-1970s or 1990s approach. And what we now see is the approach of courts to being pro-arbitration. Is that what you've seen over the time?
I think so. I think that there was a general antipathy to arbitration in the early days when I came to the bar in the early 80s, and that has mellowed, and there's been changes in legislative policy because you've seen governments around the world now, almost everybody has ratified the New York Convention, and that evinces a public policy on the part of the world community to have enforceable arbitration agreements and awards with limited abilities to challenge. And then that was followed up by the development of model law through Instratrade. And again, that's been progressively adopted by particularly the larger and more significant trading nations as a further reinforcement of the ability to arbitrate and giving the courts powers that are ancillary to arbitrators at the request of those involved. So I think also the legislative policy changed in England, for example, which used arbitration to the 1976 Act as being the main developer of contract law. Most of the cases came out of shipping disputes where there were London arbitration clauses, and all the Great House of Lords cases dealt with contracts, and subsequently it's been much harder to get to court to challenge arbitral reasoning because of this policy. And then by I think we were talking earlier about the 1996 Act in England, which has limited again, conformably with the New York Convention, conformably with model law. I think the ability of people to get out of an arbitration agreement.
Yeah, I mean it's a fascinating turn, that legislative development. So just taking the UK for a moment and the 1996 Act, that had very detailed input from the judiciary and the profession. And there's a fascinating, at least for some, including those on this call perhaps, departmental advisory committee report with people like Johnny Vida, House of Lords judges, a very young Toby Landau, writing this report saying this is how the legislation needs to change. And when you pick through that report, this type of policy of being a supportive jurisdiction for arbitration is all the way through it. So that means you end up with a 1996 Act, which really was a significant leap forward from the 1950 Act in the UK. But I think one of the things you said, Jeff, was very interesting about it's really a signal then for what the courts are meant to do. The courts are really the ones that take this forward, and you see some very big developments in the wake of that legislation over there and developments here in Australia as well.
And you've also seen it in the United States, which started off in about 1972 with Shirk and I've forgotten who, Oster Hoover or something, where the Supreme Court said, well, the United States has signed up to international arbitration and it's in our United States Code, and we have to enforce that. And that then permeated a series of decisions over the next 40 years where the United States courts have now upheld they've upheld anti-class action clauses in agreements for compelling people to go and individually litigate or individually arbitrate their disputes. And this has caused a lot of angst in terms of small claims of people, individuals who are trying to sue their employer or something like that, being forced to go into arbitration into an environment that's not necessarily as public or conducive to dispute resolution. So you've got the other side of the coin there, but generally governments have wanted to foster international trade and confidence in international trade by reinforcing the ability given by the New York Convention, which was the thing that started all this, of people to be able to enforce their obligations with people they contract with.
I mean, absolutely right, in my view as well. And so from that sort of shift in policy through the 70s to the 90s, maybe depending which jurisdiction you're in, you start to see these landmark moments in cases. And they're cases that might pop up in a different jurisdiction. They might be in the UK, the US, Australia. There's a real dialogue between jurisdictions in this area. But one well-known landmark case is that Fiona Trust case over in the UK, which said, and got a whole lot of attention for saying, an arbitration agreement should be understood and interpreted as if a rational business person would want all of their disputes resolved in one forum. If they've chosen arbitration, that's the forum. So splicing the arbitration agreement so it might point in different directions. That was a real turning moment in Fiona Trust. But it's also a slightly sort of impressive exercise in advertising by the UK Supreme Court or House of Lords in that case, because it wasn't the first jurisdiction to make this point either, but it's become a real expression of this pro-arbitration policy.
Well, that developed in the first appeal from me when I decided a case called Pan Australia and Commandante, and I followed a decision of the full court about the interpretation of the arbitration clause, which was narrow. And the full court, led by then Justice, later Chief Justice Allsop, said, no, you've got to have this, have regard to the policy reasons behind arbitration clauses and why people choose them. And what he said was picked up and cited with approval by Lord Hope in terms in the Fiona Trust case, and that then sort of spread around the world. So again, as I said before, it marked the shift in the courts, certainly in Australia, from a narrow and not necessarily pro or friendly arbitration attitude to being invasive of it.
It's very interesting because I think cases like Fiona Trust and Gala and one or two others around the world, they feel as if they're very received now. So everybody in the field knows that they exist and knows what they stand for. But they're only 15 years or so old. This is not an old set of principles. But there's been a real acceleration over those 15, 20 years of this embracing approach to arbitration. And it doesn't seem to be slowing down either. I don't know if you're detecting a slowing down at all.
Well, I mean, Australia adopted the institutional model there in about 2008 and made some significant amendments to the International Arbitration Act so as to reinforce what the full court had said in the Commandante case the year before. And I think that policy here is just now made arbitration sort of a very, very smooth sort of commercial procedure. I mean, we still get wrinkles. We had a case which I sat on, I think it was last year or the year before, Carmichael Coal, which then went on to the High Court about whether we carve out of an arbitration agreement some claims under the Australian Competition and Consumer Act. And High Court upheld the full court's decision not to stay it on the undertaking that the party invoking the arbitration clause would agree to the arbitrators dealing with the Australian claim, even though it wasn't arbitrable under English law ordinarily, and that was a condition on which the full court allowed the matter to be referred.
I mean, it's very interesting having that perspective, Judge, because as someone not in the judiciary, as a supplicant to the judiciary, I've often myself wondered what it actually means to have this pro-arbitration policy. And that's the word that's used, policy. And what I struggle with, and maybe the struggle is starting to come to an end, is what the term policy means. Is it an approach whereby the courts will generally be supportive of arbitration and try to interfere as little as possible? Or it's actually something more, that it's crystallizing into a set of principles that one applies to interpret an arbitration agreement, for example. How do you understand the policy of pro-arbitration?
Well, I think there's been a recent decision of the Privy Council in this case called Sian and Sian Participation Corp in liquidation and Halimeda International from the British Virgin Islands, but the Privy Council said this perfect law of England as well, where there was an attempt to derail an application to liquidate a company on the basis that there was an arbitration clause, therefore the debt which the petitioning creditor wanted to rely on, which was not admitted but not disputed, of about $224 million US, should be referred to arbitration. And the Privy Council said, well, no, looking at the pro-arbitration policy, that's one thing, but the whole legislative public policy and liquidation proceedings is directed differently. It's directed to the public policy of not allowing insolvent companies to trade and engage and have debts. And if there's no serious dispute on basically reasonable grounds, then the arbitration clause should not be enforced. You need to have something to show that there's something that should go to arbitration, because you're not enforcing a debt by ordering a company to be wound up. The debt remains, and part of that is reflected in the decision of the High Court in Canning Research and O'Brien, 169 Commonwealth Law Courts, where the High Court upheld a liquidator seeking to refer a matter to arbitration, where the creditor wanted to have a challenge to the liquidator's refusal of their proof of debt. And the liquidator said, you've agreed to arbitrate this, that's enforceable. The High Court 5-0 upheld that argument, which was another one of my small occasional victories in court.
More than occasional, I know from reviews. Sian is a very interesting decision, I think, from the Privy Council. Not because one might look at it and just say, oh, that is inherently correct and perfect, but rather because it continues this sort of drip development of a pro-arbitration approach, meaning something more than coincidental practice by the courts. It really gets to grips in one of its paragraphs, I think it's paragraph 49, with what this means in the context of interpreting arbitration agreements. It was quite robust in that paragraph. It really says that this policy now is how one approaches interpretation of an arbitration agreement. So interesting, slightly upgrading or bulking out of this idea.
Well, I think it's designed to reflect that the parties have entered into an agreement earlier, before there's a dispute, as to how they want that dispute resolved. And similarly to an exclusive jurisdiction clause, courts uphold bargains where they can, unless there's some public policy to the contrary. And if parties say we want to have our dispute resolved this way, then the courts want to uphold that. And particularly where you know in international trade or commerce, there'll be generally parties from diverse judicial homes who have no common ability to enforce in one country or another, who need to have a mechanism to ensure that their disputes can be determined, and then that determination will be able to be enforced. And the court's role is effectively, under the New York Convention, with very limited exceptions, to both enforce the agreement that the parties have already made that they'll have their dispute resolved by an arbitration, and secondly, after the resolution, to enforce that resolution wherever the debtor's assets may, or debtor's assets may be in the world. And I think that's really important for commerce, because they need the certainty that there will be an ability to ensure that agreements are adhered to and people keep their bargains.
And it's interesting to hear that emphasis, Judge, because that idea of anchoring the underlying rationale for this policy in the facilitation of international commerce has not gone away. That was the legislative signal that you referred to now a few decades ago. But even in CIAM, there's still that reference. It's a drumbeat throughout these decisions saying part of what we're doing here is firmly embedding this in the law of international commerce. So this policy, it strikes me, it is in some ways quite special in that it is so cross-jurisdictional. So even the board quoted from Gary Vaughan's text saying this is a significant majority of jurisdictions that sign up to this view now. But that idea of a policy which has substantive content, so it's not just a coincidence of practice of courts, but it has substantive content as to how one approaches the interpretation of an arbitration agreement, being reflected cross-jurisdictionally across a number of jurisdictions. It's a very robust concept, and one that I can't find an easy analogue for in other contractual interpretation.
Well, I mean, the Lord Briggs and Lord Hamlin in the CIAM judgment commence at paragraph 1 by talking about the appeal is about the dividing line between two areas of public policy. In that case, in the British Virgin Islands, but they then have said this is also the law for England and Wales and the United Kingdom at the end, namely insolvency and arbitration. And so they see public policy as being the driving force behind arbitration, and that theme runs all the way through the judgment of the advice of the lordships. And I think that's the way that the courts have now come to approach this, because of the legislative reinforcement of arbitration agreements. I mean, you started off in the 1850s with a case called Scott and Avery, where the House of Lords allowed parties to enforce arbitration agreements in certain circumstances. But as I said earlier, there's an antipathy towards arbitration agreements. But once you get a legislative underpinning for arbitration, the court's duty is to interpret and apply the legislation, and also to say, well, what have the parties agreed, and to respect the fact that the parties have the autonomy to decide how they want to resolve their disputes and to get sort of their money when they try to sort of enforce the high end of these things.
International commerce, it all comes down to something. But there's a permissive side as well as a restrictive side to a pro-arbitration policy. There's an article by Professor Berman at Columbia where he makes this point when talking about what it means to be pro-arbitration. You can be a flag waver, you can be an enthusiastic participant, but for judiciaries, it is to facilitate international commerce, to respect the parties' bargain when they bargain for arbitration, but also to make sure that limits are imposed, almost protecting arbitration from its own excesses. So pro-arbitration, as Professor Berman, I think, rightly argues, isn't just about sort of being a facilitator, an encourager, a cheerleader for arbitration. It's also about increasing the rigour of it as well.
In terms of trying to hold people to the constraints that the International Arbitration Act lays down, and then the model law, if that's in the jurisdiction where the sort of dispute is litigated. I think that's important. But I think one of the potential downsides that's developing in some of the United Kingdom decisions is the tendency of people to have what looks like a complete telephone book of arguments in the pleadings that, no matter how ridiculous they are, the arbitrator is said to have denied procedural fairness if they say nothing, or don't just say, well, that's a silly argument, I'm not going to deal with that. Judges are entitled to do that and to just focus on what's really an issue and decide just those matters. But an arbitrator runs the risk, because of these negative or inhibitory considerations that Professor Berman referred to in this article, and you mentioned, Lucas, that you can get this unfortunate situation where arbitrators can't use what arbitration is supposed to do, an efficient, quick and cheap method of cutting through the crap and getting to the point of why people are in dispute and resolving the substantial issues. They've got to not just resolve those issues, but every single thing there, in case one party says, oh, I was denied procedural fairness because I had this wonderful argument there, and the arbitrator didn't look at it.
Yeah.
Or thought it was rubbish and didn't spend any time analysing it.
When I first started in arbitration, I did hear it often advertised as quick, cheap and efficient. I might confess that I hear that less these days. But that interplay between the arbitration and the supervisory jurisdiction of the court is actually quite important. I think it's sometimes a bit underappreciated. What the courts do is that they provide a real openness and legitimacy and rigour to the underlying arbitration. In some ways, courts do more for the legitimacy of the system of international arbitration than the system does itself, because of the private nature of so many of the decisions. But when you come before a court and an important landmark decision like Fiona Trust is issued, that's a real injection of vitality into the arbitration system.
Yeah, well, I mean, arbitration is inherently dependent on the courts, both to enforce it and to adhere to the public policy of the forum in deciding whether or not somebody's gone too far in an arbitration or in the way in which an award was procured. And, you know, you had the recent decisions in England about fraud of the arbitrators or fraud of the arbitrators, and obviously the courts have got that overall protective supervisory role, which is so necessary to, again, ensure confidence.
Because, I mean, that supervisory role also has a coercive element to it, doesn't it? So the PNID in Nigeria case that you refer to about fraud on the award or the tribunal is very interesting, because but for the coercive disclosure powers of the various courts involved in Nigeria's pursuit of the information that turned out to be determinative, that information did not come out in the arbitration and would not have come out. So it's a real muscular level of support that being pro-arbitration provides by these courts.
Yeah, and that's the public policy. Again, it's not just a public policy to pay lip service to enforcing arbitration agreements and then awards, but also to enforcing a process that can be seen to be fair and credible and transparent to the extent that the international conventions and the New York Convention and the adoption of the model law reflect those public policies. And that's really important to process. See, Emily, has popped up on the
Yes,
screen.
I've popped up here. I hesitate to interrupt this fascinating discussion, but I just wanted to prompt our audience in case you have any questions. Feel free to put them in the chat, or if you would like to just turn on your camera and pose them yourself, that's fine as well. But in the meantime, maybe I also was wondering both of your views on how this sort of pro-arbitration policy that you discuss is generated or originated. Is it something that arises organically in the domestic context, or is it something that's sort of contagious across jurisdictions? Because you've both highlighted the really transnational element of it. How does it become in existence in different jurisdictions?
Yeah, I mean, very interesting question, Emily. And I think the ultimate source is that legislative signalling that we were talking about. So that is ultimately a domestic source. But the development of it, I think, is very curious. I mean, there are not many, in my view, and I know this would be contrary to the French approach, truly transnational principles. But if there is a pro-arbitration policy, which has now created a principle or a set of principles applying to the interpretation of an arbitration agreement, then, in my view, that is very close to a true transnational principle. So it has a source of meaning and a source of content, which is not anchored solely in one domestic jurisdiction, but rather has become something that domestic courts have taken from their signalling from their legislatures, but developed in discourse with themselves. So not quite unique perhaps, but certainly some very interesting and unusual components to the source and content of that idea. I don't know what you think.
Well, I think also the fact that you have the ultimate appellate courts like the Supreme Court of the United States, the House of Lords, Privy Council, Supreme Court of the United Kingdom, the High Court of Australia have all given over the last 40 years landmark decisions upholding international arbitration agreements or awards. And that's percolated domestically because the arbitration is then seen as a much more attractive or policy-driven for local governments approach to dispute resolution. So each of the Australian jurisdictions has its own Commercial Arbitration Act, which is a kind of the fairly model law type ones within the Australian domestic side. And that's really picked up because of the international arbitration context. I think it's developed the popularity because they've seen that the ultimate appellate courts are saying these agreements are things that parties have made to get their dispute resolved. They can choose what method they want to use, and it's the role of the courts, unless there's some public policy or fraud or other reason, to uphold the bargain. And so you've seen a significant increase in domestic arbitrations, at least in Australia, over my sort of professional life.
Fantastic, thank you. Do we have other questions from the floor?
We've all been stunned into silence.
Exactly. I don't know if you have other points that you wanted to flag still in your discourse.
I mean, one point, I mean, the title of this session was ending with where to. And I think that's a really interesting question because what we are starting to see is increased diversity of the types of arbitration. Not that these types of arbitration are newly existing, but we're seeing many more investor-state arbitrations starting to come through the courts. We're seeing more sports arbitrations starting to come through the courts. And so this idea of a pro-arbitration policy, I think, is going to come under some stress in the coming years. And by that, what I mean is that being pro-arbitration in a very familiar maritime arbitration that's been around for hundreds of years in some jurisdictions is quite a different set of considerations to being pro-arbitration in the investor-state context or in a sports arbitration context. So I think if we are starting to see this policy generate actual principle, then that is at the very early stages, which could see a real diversity of principles come. I mean, watch this space for years to come, I think.
Well, when the Sydney Olympics were on, there was a real push for the Court for Arbitration in Sport to hear all these cases, and the Court of Appeal convened an urgent hearing and upheld the award. And you know, it's so, and that works quite quickly and cheaply for the athletes because they know they've got to have a decision so they can either see whether they're in or out of the race. The investor-state area has created a real issue for governments. Suddenly, governments are realising what they've signed up for, and you've seen the really troubling attitude of the Australian government passing legislation to renege on its previously legislated agreement to arbitrate with Clive Palmer's company, and the High Court upheld the right of the state parliament to repeal its arbitration agreement and the liability that had been created under an award which was yet to be assessed in damages, because Western Australia argued that it decided that it wasn't prepared to run the risk that it could have tens of billions of dollars of damages awarded against it. It was going to get out of the whole arbitration. And so ultimately, where you're dealing with investor-state situations, there will be situations where sovereign governments won't be able to do what Western Australia did. You know, the Australian government is being sued in, I think, the Hong Kong arbitration for the tobacco advertising ban. And the question is, well, how will courts then look at enforcing those awards? Because obviously, if a sovereign government has said we're no longer going to allow our sovereignty to be interfered with by submitting to an arbitration award, that's fine domestically. The question is, how will that occur internationally? And so in Australia, you've seen the case against Spain, which has gone to the High Court once and will go back again. And you know, the High Court said, well, you can register the judgment, but you can't at the moment enforce it. And that's the next stage of what can you enforce it against, because of the Foreign States Immunities Act, and there's an international convention on that. So there's going to be a clash of public policies in that space as well. You're mute again, Emily.
It'll be really interesting to see how that policy plays out in these new evolving contexts. Well, I'm conscious of the time and I don't want to keep you any longer, but this has been really fascinating discussion. I know that I've learned a lot, and maybe we wrap it up here. And I want to thank you both very much for joining us and for sharing your insights with ICC Australia. And we look forward to seeing everybody for our next session, which will be in September.